Good afternoon, everyone. Let's go ahead and get started. I'm Pete Wellborn. I'm an attorney from Atlanta, Georgia, and internet law is what I do. I'm finally getting literal gray hair now, too, but I've been able to say, even before that I've got internet gray hair. Internet law is what I've done, believe it or not, since 1996. I started representing Earthlink not too long after the attorneys at my firm emancipated Sky Dayton, the founder, so that he could sign business contracts when he was still 17 years old. So this area is near and dear to my heart. This is my either fifth or sixth. I was trying to count up with Bennet, Kelley here how many I've been to, but as I said, this is something I have a lot of passion about. And I'm especially excited about the talk today, probably more so than any talk I've ever given, because I think it's the most important one that I've ever given. And that's because of what all's going on with the FTC and all the new laws and rules, and exactly where the crosshairs fall now as far as the government targets on members of the affiliate industry. Most of the time in these talks, I'll caution you about attorneys that I call nervous Nellies. They're the ones who see every real life situation as though it were a law school problem. You'll ask them, can I do this? It makes great business sense. And if there's some obscure reason, if there's an 1847 case that implies that you probably shouldn't do that, they'll tell you, no, you cannot do that, and here's why. They don't understand that every legal decision, and especially in this context, is a business decision. So usually I'm up here saying, don't worry. I'm up here saying it's a business decision. Make sure you're informed, but make the decision. If there's some legal risk, so be it, if you think that the business rewards outweigh it. I'm here today to say worry a little bit. Really think about what you're going to do, because with the new government regulations and the FTC's pronouncements, if I wasn't on film, I would probably use a four-letter word here, but it's a cluster, you know what, and it really is. So I want to talk today about avoiding liability. I want to talk about the FTC's new regulations. I want to talk about their bizarre open letters and pronouncements and statements, their self-contradictions. And as we talk today, please keep this in context. I could have the most learned internet lawyers in the world here and talk for a week, and we wouldn't be able to cover every single thing. They would not be able to walk out of this room knowing off the top of their head every single thing. They wouldn't be able to answer every question that ever came up without reference back to the regulations or to the written laws. And so here today especially, I'm assuming most of y'all are business people and not attorneys. The key for you is to understand the issues. It's not knowing the answer, it's knowing when to ask a question. And I'll repeat that because it's so important. It's not important that you leave here today knowing the answer to every question that you may have about a testimonial or about an endorsement or about an Oprah lawsuit type situation. What's important is that hopefully you leave here with a little bit better feel of what questions you should be asking and when those red flags should go off. As I said, I'm Pete Wellborn. This is Bennet Kelley. He'll introduce himself a little bit more. I've known Bennet for many, many years, going back to when he was general counsel at Value Click. Very good guy. I'm excited that he was able to be with me today and to talk with me today. Just to get us started, as I said, be it fair or not, I think it's not. It's really, affiliate programs are a victim of their own success. This is an industry that did not really exist, 10 years ago, 15 years ago. It was a very different industry and very different money dollars even a few years ago, 5 years ago, 6 years ago. We affiliate program industry members are victims of the financial success. The government sees dollars, and I think that's the motivation of why they have really, literally as this slide shows, put affiliate programs right there in the bullseye. Everything we're going to talk about today can be summed up in 3 words in relation to advertisements and messaging: truth, proof, and fairness. Truth, proof, and fairness. I mean, that's the bottom line. And I'm going to get through this real quickly because there's so many gray area issues about endorsements and testimonials and advertising that we want to cover, but just the basic framework here. The FTC prohibits deceptive ads and unfair ads. Bennet and I had a long, very interesting debate last night, each arguing both sides at times, but FTC says that their rules are identical in a bricks and mortar setting and a .com setting. That's true to a certain degree, but when you really start to analyze their examples they use, some of their statements, it's clear that they're not even following their own statement here. So it's the same, but it's also a little bit different. What is a deceptive ad? A deceptive ad is one that's likely to mislead the consumer, and that's in the whole second part there, a lawyer would say material. It's likely to actually affect the consumer's decision. Misleading. That means relevant information is left out, or there's a false claim, or there's an unsubstantiated claim, a claim you cannot prove. Some of the common ways that you see these violations in advertisements, in the disclaimers and disclosures that we'll talk about, the rules have changed dramatically. Every time from now on you see a TV ad or an ad on the internet, or God forbid one of your affiliates sends something and it's got tiny, tiny print that says results not typical, that's probably a violation now, and that's one of the ones that the FTC is going after. Demonstrations. I remember years and years ago on TV, Tonka toys. Anybody play with those when you were a kid? Am I that much older than everybody? The little toy trucks. On the commercial, they had an elephant stomp on one of the trucks and it didn't crush. And it actually would have crushed like a pancake. They got in trouble over that, so be careful with demonstrations. Refund policies, ads directed at children, environmental claims. Bennett's going to talk about when you can use the word free and how not to get in trouble with that. Jewelry-related claims. There are a number of different ways that you can violate these guidelines by the FTC. The other half, deceptive or unfair. Unfair ad is one that causes or is likely to cause an injury that's substantial. It's not outweighed by the other benefits, and I can tell you, it almost never is. The FTC hardly even discusses that element, so don't think you can hide behind a, well, you know, yes, there's injury, but it's outweighed by the good the ad can do, and it's not reasonably avoidable. FTC is going to tell you that everything is reasonably avoidable. This may be the most important slide of the entire day right here. This is crazy. This is where the FTC ignores the law. Any other business situation, liability can flow up the chain, but not down. If a driver for Coca-Cola driving a Coke truck has a wreck, you can sue that driver personally, and then because he is the agent of Coke, who's his principal, you can also sue Coke, you know, if indeed the truck driver was carrying on Coke business when the accident occurred. Typically, if something goes wrong at Coke over here in the bottling department, you can't randomly sue a driver over here. FTC is seeking to change that in a way, and it really is scary. Who might be liable? Assume a hypothetical ad where, you know, there's a false statement or where there's not the required disclosure of monetary compensation for giving the opinion or whatnot. Who might be liable? The seller may be liable. The ad agency may be liable, even if it's just a middleman. The website designer may be liable. Believe it or not, I didn't make this up. It's in the FTC's documents. The website designer may be liable if he didn't take a look and think, I better investigate to see if there really is a study that backs up this claim that 47% of users of this body mass benefit from the acai berry. That's crazy, but that's what they're saying. Affiliates may be liable. Any individual personally involved anywhere in the business chain may be liable. And what is the standard for that liability? It's a negligence standard. That is pretty common in law. It's whether or not that seller, that ad agency, that affiliate, that sub-affiliate, whoever, whether they knew or should have known of the deceptive or unfair nature of the ad. Now, what does that mean? I mean, that sounds great in theory, but I'll tell you what that means. It means whatever the FTC tries to say it means when they sue, and it means whatever they can convince a judge who may or may not have an agenda, you know, what it means. That's not a mathematical formula. That's not something that you can take as an absolute stone wall protecting you if you really were not involved in making that unfair or deceptive statement. As I said, you should worry. Worry up the chain and worry down the chain, and make sure to the extent you can, you control everything that you can control. And then by contract, by your agreements, by your T's and C's, make sure that you exert as much control over people down the chain and even sideways in the business model as you possibly can. Because you sure don't want to find yourself liable because somebody over here with whom you had a peripheral relationship was making outlandish statements or throwing up more Oprah or Dr. Oz endorsement ads without having permission. I told you today that one of the key factors is going to be not knowing the answers, knowing what questions to ask. This is a very, very partial list of laws with which the FTC is charged with enforcement. So ways to get in trouble with the SEC is what you could call this slide. I'm not going to go through every one, but it's everything from truth in lending to mail order merchandise, negative option, lots and lots and lots of laws. So again, if there's a theme today, know what questions to ask. Know when a red flag should have been raised. Rules of thumb. If you don't remember any of the particulars, any of the statutory sites, any of the examples that the FTC actually gives that we'll talk about later, rules of thumb. If it's an advertisement, make sure it's true. Look at things from the consumer point of view. That's something that we'll go back to time and time again today. Would the consumer expect that person to be getting paid for saying whatever they're saying? Would the consumer know whether that's an actor or a real spokesperson consumer? What does the end user consumer think? What would a reasonable one think? Make sure you can prove what you say. Understand that the rules have dramatically changed about disclaimers and disclosures. You can't say this person lost 300 pounds in 2 weeks using this particular weight drug and then put results not typical. It doesn't work anymore. And as the folks who were sued by Oprah and Dr. Oz would tell you, be real careful with endorsement claims as well. As I said, we're going to talk about testimonials and endorsements in some great detail. That includes flogs, which are the fake blogs, a very hot issue now. We're going to talk about when you can advertise free stuff, which is something else the FTC loves to get people for. And then we're going to talk real quickly about proof of claims. At what point do you need scientific evidence or some kind of mathematical data to back up what you're saying? And that's another area that we can have a lot of fun with about the FTC's contradictory ideas. With that, the first thing is celebrity endorsements, and I'm going to turn it over to Bennet Kelley.
And naturally, they would turn this section over to the guy from LA. But I first met Pete 8 years ago at the spam summit at the FTC, and he had the same kind of energy and passion over spam back then. And I remember leaning over to someone and referring to him as the Tasmanian devil of the internet law. But and he's still that today. So I love this slide. Just by way of background, I'm Bennet Kelley. I'm with the Internet Law Center in Santa Monica, and I'm co-chair of the California Bar Cyberspace Committee. And so we're going to talk a little bit about celebrity endorsements and endorsements in general. I love this slide because it kind of encompasses everything we're going to be talking about in a nutshell. And I'm going to start it by, first of all, before we talk about celebrity endorsements, are there any celebrities in the audience? Guess again. Any event, before we talk about that, there's a quote I love from a movie called Body Heat. And it involves a scene where Mickey Rourke he plays a small-time hood, and he's talking to his lawyer, played by William Hurt. And there's a little role reversal going on, because William Hurt is asking Mickey Rourke for advice on how to make a bomb. And Mickey Rourke, conscious of the role reversal, says to William Hurt, quote, "Counselor, remember you told me that anytime you try to commit a crime, there's 100 mistakes you can make? And if you're a genius, you think of 20 of them, and believe me, you're no genius. And I mentioned that quote for two reasons. One is that I often bring it up as a way with people who are trying to be too cute with the law, who think they can come within, a quarter centimeter of what's going over the line, and they think they have it all figured out, just to suggest to them that maybe they're not as smart as they think they are. But I bring it up in this context because the whole thing, if you're a genius, you can think of 20. Well, these guys didn't even come up with 2. Let's start from the beginning. So this ad, the acai berry, this Brazilian berry that supposedly does all these wonderful things and causes people to lose weight. Well, none of the claims have been substantiated. The endorsement, non-existent. In fact, the photograph of her on Tonight Show is from several years before when she was pregnant. So that's pretty dramatic weight loss. And it gets better. They did the same thing here with Oprah and Dr. Oz. This was a non-endorsement that they promoted. And the thing here is you can get whacked for 2 things. It's not just deceptive advertising or deceptive trade practices that you can get liability for with the FTC, but you also can be liable to the individuals. And in this case, Oprah has sued. And in California, New York, and several states, there's a thing called the right of publicity, a right of personal privacy, and that if someone uses your image without your likeness, or in some cases even your voice, or an imitation of your voice, without your permission, they have liability to you, and they'll have to pay whatever the going rate would be for the use of that. And the liability doesn't attach just if it involves a famous person. I recall a case where there was a doorman at a hotel in Vancouver who just happened to be in the faint background of a print ad, and he got a 5-figure settlement. So, I mean, it was a ridiculous case, but even still, it's a risk to be aware of. So, when we talk about endorsements, there's several things, some of them are quite obvious. The first is that, one, it has to be a real endorsement. You don't want to be promoting an endorsement that doesn't exist. And it has to be the honest belief of the endorser. And a telling sign of the state of the law today is that I looked on the internet, and there's now a product for endorsement liability for insurance. And so an endorser can be liable if they make false claims in their endorsement, or if they know they're false. And are you all familiar with the TV show from the 80s, Lifestyles, The Rich and Famous? I don't know if many of you remember that. But Robin Leach actually had to enter in consent decrees with about 8 or 10 different attorney generals for sponsoring deceptive ads for a travel scam. And so the endorser has liability. Now the thing is, let's just say hypothetically, the acai berry did what it said it did, and that Britney Spears actually endorsed it. If acai berry comes out with a new product, they can't use that same endorsement for a different product. Or if Britney stops using the product and now uses another product instead that she thinks is better, they can't use it again either. You have to present everything fairly. This is true in any ad. You can't take things out of context. You can't cut and paste phrases to create an endorsement that doesn't exist. And as we said, it has to be a bona fide claim and ongoing. Do you want to do the consumer part?
And I'll just do that from here, this one slide real quick, because I'm going to talk about this more in detail. How many of y'all are familiar with the hot issue right now of the flogs or the fake blogs, the mommy blog issues? I see some nods. That's typical situation here. Mother has a blog on parenting and kids. 2,000 or 3,000 followers. It started off just as a hobby for her, but now it's got a great following. She gets maybe a box of diapers or a new toy or whatever to review. No promise from the toy company, the diaper company, what she's going to say, but they'll send it and say, thought you might want to use this, and if you like it, comment on it. The government is now is going to, if there is no disclosure, when that mommy blogger puts these disposable brand diapers are the best ever, on her blog without disclosing that financial relationship, or disclosing at least that she got the product for free, that is a violation of federal law that the FTC says it can and will enforce. So consumer endorsement, that's what that is. That's why this is a hot area. It's basically a non-celebrity endorsement, an endorsement by John Q. Public or Joe Everybody or Jane Everybody who uses the product. When there is such an endorsement, the claim has to be representative. I mean, it's got to be true of what most people could expect when they use it. It can't be the exceptional outcome. It's got to be what's expected. It has to be substantiated. There has to be some kind of proof to back it up. And maybe it can be disclaimed, maybe it can't. We could talk about that for 2 hours about what words would or would not constitute an effective disclaimer. As I said, you cannot get away with results not typical any longer. You at least have to say what most people would expect. Actually explain the results most folks would expect to get. The consumer endorser is held to the same standard as the seller. So if there's a statement that the seller could not make because it would be deceptive, there's no right granted to the consumer spokesperson to say the same thing. If he or she says it, that's liability just as if the seller themselves had said it. And then finally, an actual consumer has to be just that. You can't have an actor who plays an actual consumer. It's got to be a real, live, normal person. And we'll talk a bit more about that in just a little bit when we get to the blog section. Bennet?
All right, moving down. Expert endorsements. When we talk about an expert endorsement, it has to be just that, an expert. So, for example, Dr. So-and-so says this is the product that can save your life. Well, if he's a PhD in engineering, that's not the person you want for medical advice. And it has to be the actual exercise of expert opinion. It can't be something just, I read this somewhere. This has to be his expert opinion. And the claims must be true as stated. Now, when you get to an organization, it has to be a real organization. And this is interesting because there's a little divergence in political advertisements in that often you create a front organization to run controversial ads and, committee for whatever, and which often means it's the committee against whatever. But here, if you have an organization that's endorsing you for a product or a claim, it has to be a real organization. So if I just said, affiliate summit panel of a PhD scientist, which probably doesn't exist, if I did that in the ad, I'd be violating the FTC guidelines.
Material connections. This is where the FTC intends to get the mommy bloggers of the world, the consumer endorsers of the world. And most of y'all, I'm sure, have seen the movie The Wizard of Oz. Remember the part where they're visiting the wizard and I think Toto pulls back the curtain and the wizard is saying, "Pay no heed to the man behind the curtain." That is exactly, y'all, that's exactly what the FTC is doing. The FTC has promulgated rules by which that mommy blogger would be liable. But then it puts in an open letter, ignore what it actually says, just listen to us. We're only going after the seller. We'll probably just send the mommy blogger a warning letter. I mean, that is ridiculous. I run into that. We do some non-technology work for our clients, for our technology clients as well, and we see it lots of times we're negotiating a lease for office space, and the landlord will say, yeah, it's true this provision in our form lease gives us the power to take his firstborn child if he's one day late on the rent, but don't worry about that. We never enforce it. Well, fine, take it out. It's the same thing with the FTC. They're writing one thing, then trying to back off from that, but I guarantee you, when someone tries to rely upon that statement to trump the law and say, well, you said you were going to send a warning letter first. Yeah, it's a violation, but you said you were only going after the seller. That's not going to be a defense. So this is a mighty important issue right now. Material connections must be disclosed. What is a material connection? That's any connection that an end user, a viewer, a normal person reading the ad or watching the ad might not expect, and that may affect the weight or credibility that the ad should be given. This often applies where the endorser is not a celebrity. But that's not an absolute rule. There are all kinds of permutations and combinations out there that make this truly, truly a gray area. Now, the connection, the money that's paid or whatnot, the product that's given, the consideration that the reviewer receives, that the end-user reviewer needs to know about, that can be money. It can be product. It can be publicity. I mean, it can literally be having your name in the paper. So again, it's a super gray area, and my undergrad degree is computer science. And I loved math in college because there was a right answer. You sat down, you could do it, and it was either right or wrong, and that was that. And law can be a little frustrating sometimes because many times there are answers you can get to, but way too often, and especially when laws are inartfully written, it's so gray that anybody can say anything they want, and it's at least a colorable argument. And that's a very dangerous thing to have when you're trying to tailor your conduct to comply with that law and yet still be as aggressive as you can to make as much money as you can. This material connection rule applies especially to the blogs and flogs. Flog is the slang for fake blog. I don't know if any of y'all heard about Walmarting across America. That's my favorite one. That was a blog that a husband and wife started. Their family vacation was to RV across America, and they both loved shopping at their local Walmart, so they would go from Walmart to Walmart. And the nice folks at Walmart in those states in those cities would sometimes let them park their RV right there in the Walmart parking lot. And anybody that followed would take a look at their blog and see that they were in Arkansas, the home of Walmart today, and they went to the original store, and the people were so nice, et cetera, et cetera. Well, come to find out, that was a Walmart advertising campaign. That's not going to be permitted anymore. Sony did the same thing with PSP a few years ago. There are all kinds of campaigns like that. They are absolutely forbidden by the rules as written by the FTC. And yet, as I said, write one thing, say another. The FTC has also said they understand that creative and guerrilla marketing tactics are a valuable way of advertising one's services and products. So they do not want to have a chilling effect on those. But at some time during that campaign, the truth has to come out. When is that? After they Walmart across America, halfway across? There's really nothing there that can let you knowingly tailor your conduct to make sure that you're in compliance. And I'll tell you, I said at the beginning of my talk, everything we talk about today is a business consideration. It's not a nervous Nelly legal issue, it is a business consideration. And if you followed the advice that the nervous Nelly lawyers gave, you'd never get sued, you would 100% be in compliance, but you wouldn't make any money either. So all these gray areas we're talking about are going to be trade-offs that you have to make a knowing decision about of how aggressive do you want to be with your marketing campaign. Just a few examples of the material connections. And I'll take hands or somebody just yell it out. I'm a drug company. I want to have an honest-to-goodness study to let me know whether my drug is effective in this particular demographic for this particular illness. I make a big contribution to a company that studies those things and ask, don't want a good opinion, bad opinion, only want the true results. Here's the money to fund the survey, go to it. They do their neutral, honest survey. Turns out that the drug is super effective. Can I use that without saying that I paid for the study in my advertising? No, exactly, that's right. Even though there were no results promised, it's something that could affect the credibility of the study. All right, how about this one? A celebrity, fat Britney Spears does a commercial for Kentucky Fried Chicken. She's getting paid for that, obviously. Must they disclose that in that commercial that she's getting paid to say it's finger licking good? No. And again, it's not intuitive. The answer there is no, because the normal person sitting at home would expect that Britney Spears is getting paid to say that. What about Greg Maddux? If you're a baseball fan, one of the best pitchers ever, pitched for the Braves, super effective back in the mid and late 90s. It was a big deal in Atlanta when he had LASIK surgery to correct his nearsightedness. And let's say a baseball player like Greg Maddux has that surgery. He's actually compensated by the doctor's practice and the company that did the LASIKs. He goes on the Jay Leno show, hypothetically, and this is just made up, but goes on the show, and during the course of the conversation, he says, "Oh, I got to tell you, Dr. Smith and the Smith practice in Atlanta, they did me up so great. My vision is the best ever, and that's what I attribute my season to." Any violation there? He's just chatting on the Leno show. Yes.
Yes.
The normal person would not expect that someone who mentioned in passing that he had great results with his eye surgery was actually being paid by his eye surgeon. And I could go on and on and on. Suppose exact same show, same situation. Greg Maddux is wearing an Izod shirt because he has a big clothing contract with Izod. Does he have to disclose that? No. I guess because people would expect that if he's wearing something somebody paid him to wear, he's getting paid for it. I mean, it doesn't really make sense, and it's really tough to be able to forecast exactly what the FTC is going to say in every one of these situations. But in the affiliate setting, especially if you use any consumer statements, especially if you use any kind of blogs, if you use any kind of non-celebrity endorsements, even if you use celebrity endorsements, but especially if you use non-celebrity endorsements in any phase in your advertising, or if any of your affiliates or sub-affiliates use this. And that's very important because remember, if the FTC has their way, it's absolute liability for everyone in the picture, period. Doesn't matter if it's your fault or not. Doesn't matter if you're up the ladder, down the ladder. It's going to be your liability. With that, I'm going to turn it back over to Bennet and talk a little bit about use of the word free, which is another very hot topic.
We're really short on time, so basically we're going to do this really quick and try to get whatever questions you guys have. Basically, if it's free, it has to be free. And all of you probably who've been around this space for a couple of years have seen the millions of dollars that have been paid out to the FTC and to the Florida Attorney General on the ringtone campaigns. And if there are any conditions associated with free, they have to be disclosed up front, clear and conspicuous. The FTC to really crack down on this, as did the Florida Attorney General. In fact, the Florida Attorney General has detailed guidelines. If I can talk to you about that later, or go to their site. And do you want to do the proof of claims or just go to questions?
No, we've got no plan for this. We're fine.
What?
We're fine.
Okay, you want to do it?
Bennet was asking, this is such a gray area. I want to make sure that we have time to talk about what y'all want to talk about. And this is a nice sized group. Usually I actually go person by person before the talk and find out who you are and what you're here to hopefully hear about, so I can tailor the talk to whatever you want to hear. I've had a little bit too many people do that today, but we want to make sure that we're leaving plenty of time for questions because we want to answer the questions that you want the answers to. So I'm going to hit this real quick and then we'll go to questions. How do you have to back up what it says in your ad? And again, this is a very gray area. So some things are matters of personal taste. Some things are not. Even in the FTC's own examples, there has to be backup, scientific, mathematical backup for a survey where people said that this cake mix is as good to me as a cake made from scratch. But there doesn't have to be any backup or proof or whatever of people walking out of a movie and saying, this is the best movie I've ever seen. I really enjoyed it, liked it. So, according to the FTC, I guess cake taste is mathematical and movie taste is not. And it just doesn't make sense. But to the extent we can make sense of it, required proof of ad claims. Anything in the ad, and I keep saying your ad, but remember, that's your ad. It's your affiliate's ad. It's the agency's ad. It's anybody that's in the chain of your affiliate relationships. There has to be some basis for every express and implied claim. express an implied claim. What you're saying the product does has to be reasonable as far as what you're saying it does, how you go about saying that it does that, the context in which you're saying it does that, any limitations that you place. Depending on your product or your service, it's going to vary as far as the amount and type of proof that you need. If you have any kind of health or medical product that you sell or help sell or that you advertise or that your affiliates advertise, that's going to be probably the highest level because obviously that's the one where false claims could do the most damage. How important is a truthful claim? How much benefit would it do? How harmful would an untruthful claim be? How much does it cost to figure out if it's what you're saying is true or not? Consequences of a false claim, et cetera. So be aware that certain claims that you make about your product may require some degree of scientific or mathematical proof. When is the scientific evidence required? If you use math in your numbers, first off, if you say 4 out of 5 dentists agree, whatever, then you have to have some proof for that. It's not enough. This is another important theme of all the new laws that the FTC has put out. Anecdotes are not enough. Testimonials are not enough. It does not matter if you find a consumer who will swear on her grandmother's grave that your product cured her baldness. Doesn't matter. There has to be some scientific proof to back up, even if she's given her honest opinion, because she can't say as a consumer something that you couldn't say as the seller. That's a good way to remember it. Look at the quality of the evidence that you have to support what you're saying. Look at the totality of the evidence. Make sure that you're not ignoring any unfavorable results. One of the FTC's examples is a dermatologist is hired to endorse a product, an acne product. She believes it works until she sees a study that really calls into question the efficacy of that particular product, and the dermatologist just ignores it. That's a violation there by the dermatologist and the seller. And if you believe the FTC, the advertiser, the publisher, the website designer, the affiliate, the sub-affiliate, et cetera. And finally, make sure that if you do have some study or some proof, make sure it matches up with what you're saying as far as the relevance. An example there, going back to a drug example, if I manufacture the ABC drug and in my advertisement I say, Doctors Hospital here in Las Vegas chose the ABC drug over all other competitors, and I imply it's because my drug is better, it gets better results. But in fact, they chose it because it's the only one of the competitors that's packaged individually, even though it's maybe not quite as good or at best as good as all the other ones. I can't take that choice and then put a different spin on it or make it relevant where it really was not relevant to the claims that I'm making. With that, this is, I think it might be lost in the lights, but that's supposed to be a cemetery in a deep, deep fog. And that's really what this law is right now. I hope and Bennet and I have done it justice today to at least get the red flags up, at least cause you to know when you should think about something, when you should scratch your head, when you should be a little bit worried that some other player in your industry, in your field relationships, may bring liability to you.
Here's a good example, as a discussion point that kind of make you think. I mean, you're all familiar with the fact when you have clinical test studies, and it sounds like Oz when you use this phone. When you have clinical test studies, there's always a control group that gets a placebo. And actually, in almost every study, there is some positive response among some of the control group. And I've always joked with FTC people that I'm going to launch a website called placebo.com, and I can advertise that it's been proven effective for curing cancer, for curing diabetes, for curing blindness, and in an extent that is true. But it's also deceptive because I'm not really disclosing everything involved. And by the way, please go to placebo.com after the show. And so that goes to the second point I'd like to make, and that is that when you deal with these things, think of discussing it over the dinner table with your family, your kids, or your grandmother, whatever. And would they be confused? Would they say that, well, that's not fair? And that's really what it boils down to. That's how the FTC is making the determination. Although one thing we were debating was whether or not there was a double standard being applied to the online space. And when you talked about the mommy bloggers, I was going to interject, if that mommy blogger left her house and then took a cab down to New York and started writing at the New York Times and wrote the exact same thing in print, she wouldn't have the same disclosure obligations. And there seemed to be, and if you look at the explanation that went in the Federal Register, there seemed to be this kind of old bias that print media is reliable, and that blogs are these people sitting at home in their bathroom slippers, when actually some blogs make more money and actually get more readers than a lot of newspapers today. I actually saw Arianna Huffington speak to a group of newspaper writers and said, believe me, it's not me. I'm not the one to blame for you losing your jobs, but there is a lot of blogs that get a lot of readers, and I think there is what I call a double standard, or sometimes what I refer to as internet exceptionalism, the belief that somehow the internet is a different space, and so different rules should be applied.
Yeah, and the lines are definitely blurred. I want to talk about now what y'all want to hear about, so I'll take questions.
You mentioned a while ago that there's kind of a string of people that can be responsible in the event of a lawsuit. I own an agency. We've got web designers. We've got agreements with a client, and I'm just wondering if there's a way that we can, in our agreement with the client, and we deal primarily with nutraceuticals, which are like supplements and vitamins. If there's a way to transfer that responsibility for the accuracy of the information to the client.
Absolutely. That is a great question, and to make sure it shows up on the film, I'll repeat that. The question was, in the context of an agency, and especially one that does a lot of work with nutraceutical clients, how can you protect yourself? How can you transfer the liability? And the key there is to have bulletproof agreements. And that's not only with your nutraceutical client, with the seller, that's also with all the affiliates, with what you require the affiliates to have with their sub-affiliates. That's horizontally, up vertically, down vertically. And you need to make sure, all the way down to if, what's okay for your affiliates to use in their advertisements. If they do cite a certain study, or if they do use a certain celebrity endorsement, they have to have this. They have to have that phrase. They have to have this disclaimer. With the nutraceutical companies, if they are, suppose they come to you and say, yeah, we were endorsed by Dr. Oz. Here's what he said, and that's true. Make sure that your agreement with the nutraceutical company has provisions saying, if the formulary is changed of the drug, or if you will periodically monitor Dr. Oz to make sure that he still believes these comments, because as written right now under these newly promulgated FTC rules, if Dr. Oz decides 6 months after he gives that endorsement that he hates it, that it's a fraud, that it's not a good product, and the company keeps on blindly advertising this product by blindly hiring you, and you continue on with what you were doing because it was fine 6 months before you checked it out, as written, you are liable under the FTC rules, because it's your responsibility, as well as the nutraceutical company, to periodically check with Dr. Oz to make sure he still has that same favorable opinion.
And this is where the Mickey Rourke law would come into effect, because if you're playing it too close to the line, you're banking on all your affiliates down the line getting it right. You're banking on them not making any changes, not making any screw-ups. And so, the closer you get to the line, the more risk you're taking because you're relying on other people.
I still follow-up. You mentioned acai bowl a while ago. It was mentioned on Oprah. Dr. Oz has, as part of the top 10 superfoods of 2009 or whatever, has a super high ORAC rating. It's super high antibiotic, free radicals, free radicals.
That is a great question, and it's one that gets into right of publicity, which Bennet talked about, and it's a little bit of a gray area. The right of publicity rules are going to change from state to state, so a lot of how that would come out depends on which state they, would sue, a Dr. Oz or an Oprah would sue in. But the quick answer is this: you can certainly mention if they have, touted the effects of the acai berry on their show. That can be mentioned in certain circumstances, but what you cannot do is to give have a poster-sized picture of Oprah and Dr. Oz, which crosses the line as far as using their likeness to sell the product and causing one to believe that the product is endorsed as opposed to just that random statement. Good example, actually Mark McGwire back in the news. Any baseball fans here, he was cheered and applauded like he was the returning hero when he was hired in St. Louis to be the hitting instructor, after finally, bombshell of all bombshells, admitting last week that he used steroids when he played. But there was a case 10 years ago, 15 years ago, somebody handed him some off-brand energy drink, said, taste this. And so he tasted the drink, said, oh, that's pretty good. The person who had set it up snaps a picture of him drinking it, and then honestly had an ad that said, Mark McGwire drinks this drink. Was it true? Well, yeah, but it was using Mark McGwire's name and likeness to sell the product unfairly. And so, that example clearly crossed the line. And the last point with the Oprah and the Oz lawsuits, besides just saying what they said, which maybe would have been okay on their shows about the berry, they used the big pictures. They made those statements the cornerstone of the advertising campaign. And worst of all, they didn't say what they said. They basically manufactured comments that were in the first person and that promoted those particular acai berry products.
The thing to remember is, assuming they got everything right in those ads, they would still be in the crosshairs because of the negative options that they're using. And that is a major priority if the FTC, they actually have stats. If you go to the website, you can see just the ramp up in enforcement on negative options. And I actually had drinks actually with someone at the FTC, excuse me, at the Justice Department recently, who said that they see this as a model for consumer enforcement. And so negative options you have to look at very carefully. And I think the acai berry one was pretty egregious. In the back?
Behind. Actually, right behind the gentleman that just asked the question. Then we'll get back to you. Yeah.
Yeah. Well, on the negative options, when you say free is free, what does free trial fall into the whole mix? I mean, when I write it, and I say, free widget, and they come to my website, and I say, get your free widget, and then they come down to the billing option, and it says free widget for 7 days, and then it goes into a 1995, and even to be compliant with Google, I'd have to make them opt into that check. I'd have to check into or add a checkbox, into the 1995 price. Is that going to get it into trouble? I mean, it's a free trial, and I didn't use free on the ad. I didn't use free in the headline on the landing page, but it's a free trial.
All right, so, oh God, I hate that. And so if I hear you right, and we do the free trial, can everyone hear me?
Yep.
All right, we do the voice, I'm named after a priest, but I don't want to have the voice of God thing. If we do the free trial, well, what are the terms of the free trial? And where are they disclosed?
Yeah, okay, so like a free, it's a subscription product, $20, $20 a month, but they get a free subscription for it's free for 7 days, you'll not to the 7th day, and at which point it's $19.95 a month.
All right, and so the key for you or anyone else in that space is, where is that disclosed and how clearly is that disclosed? And as the consumer, for example, I would make sure the consumer is checking something, or have that as right by the box where they click, I accept, that those disclosures are made. Now, the problem in those type of things in search ads is you only have so many words. And I think the FTC cuts you some slack on search ads, but in email and with web landing pages, you have a lot of leeway, and so you should be clear in that.
And there are actually some relatively clear guidelines from the FTC on negative option products. That's one of the things that I spoke on, I guess, 2 years ago here at Affiliate Summit. So I've got a whole library of that. If you want to call either one of us, I'll be happy to share that with you. And by the way, if any of y'all want to call me with a question later, whether it's to catch me in the hallway, call me next week in Atlanta. The meter will be off. I have another presentation that I do pretty frequently for the technology incubator for Georgia Tech. It's called ATDC, and it's called How to Not Get Screwed by Your Lawyer. At least that's the unofficial title of it. And I saw lots of things at the humongous firms I was at before I started mine. Lots of bad things, some good things too, but lots of bad things before I started my firm in 2001. And I'm sure Bennett's the same way. I'm not trying to plug myself. I'm just saying, make sure you get an attorney who cares about you and who doesn't have the meter on every single time you ask them a question. I've seen attorneys at big firms bill a client for a condolence call when the client's daughter died.
That's famous.
Honest to God. I've seen clients, attorneys make a big deal of taking the client to a fancy dinner. Oh, no, I'll pay. We appreciate your business. And then on the bill is that charge plus an hourly charge for the attorney's time at dinner. No lie, I swear. So if you have any questions, something like that, call me next week. I'll pull a notebook out and we'll talk as long as you need.
You must be really popular with the Georgia bar. So we have a question.
Hi, David from daviddamon.com blog. I know that AOL has certain words, like if you're going to use the word free and it's a trial, you have to do risk-free or do free with an asterisk. What does the FTC think about that? That's just an internal AOL deal since I build websites for other people.
I'm not specifically familiar with the AOL policy, but I would be willing to bet that it is more detailed and more protective, even than the FTC guidelines. If it's not, then it doesn't make any sense. So I think that's probably a safe assumption. The main thing with the FTC is that you need to have them in the same place. It's really bad to have a hyperlink that goes way over here or to have super fine print. You need to be able, if you can see the word free, you need to be able to see what free means, basically.
And that's true, not just in free. If you haven't gone, you may just a good detour at some point is go to the FTC website and look at guidelines, business guidelines, advertising guidelines, and they have some really useful examples. And the best one to look at is the .com disclosure examples, because it talks about qualifications you need to make. And so, for example, they use the example of diamonds, FTC diamond mines. And if you're going to say this carat may not exactly be a quarter of a carat, and given the way web pages are laid out, you can't use the asterisk and then disclose it at the bottom. You have to have it right near where the person's viewing it. And there's a whole host of other examples that are there. There's examples, there's a pricing guidelines. So for those of you in the e-commerce space about when you can save 85%, for example, that's there. And they even have guidelines on the use of the word free. So at some point, it's a very useful site to visit.
And if, as I said before, if you call, I actually have that document in my briefcase, as a matter of fact, but I can give you the URL, to pretty much anything on the FTC site that you need, as I'm sure Bennet can as well. Red shirt right here.
Does this apply to video marketing as well? If you post a video on YouTube and then send someone to a website, does your video have to be fully compliant, or does the website have to be?
That is a great question, and I think that's actually one that probably has a black and white answer. And the answer is yes. Everything we've said today applies, whether it's newspaper, whether it's video that directs you somewhere, whether it's some other kind of print advertising, online, all the above. And that's one thing that it does say that the FTC is fairly consistent about in all these new publications, is that these rules they're making apply everywhere, not just any one particular form of internet advertising.
I think the only way you would see exceptions is in search, just because of the limitation of words. But if there's a capability to have adequate disclosures, they're going to demand it.
Although, I had a professor, I thought it was the dumbest thing I'd ever heard when I was in law school. He could ask you, does the sun come out at day, moon come out at night? no matter how obvious the question was, if you didn't answer him by saying yes and no, you were wrong in his class, no matter what he asked. I thought that was dumb, 25 years ago when I was in law school. I think now it's one of the smartest things that, that I've ever heard, probably. So to give you the no, you don't have to answer to the same question I just said, probably yes. If I were defending a client who had some kind of video on YouTube that took viewers, directed them to somewhere where the real advertisement was, I would say that is the very type of original marketing, guerrilla marketing, creative marketing that the FTC said would be okay not to have these disclosures as long as they appeared at some point in the ad process, which in your hypothetical they do once you get to the real website or the real ad. So it just depends on exactly what the details and the context is.
Did you hear about that ad campaign? I actually called it WTF marketing. There was this ad campaign done actually in the Los Angeles area, I forget, by a major agency, where they would get these, people would get these phone calls, women primarily, phone calls where it would be some guy with an English accent saying, hey, I'm going to be coming in to visit you, hope all's well, maybe come in by late at night, so just leave the door unlocked. And he kept repeatedly calling, and then a friend would call and say, hey, watch out, he's really drunk, he's kind of scary, and more or less creating the sense of fear in the people receiving it. And then eventually, there's a message, and they click on the message, and it's an ad for a car. And I never quite understood how that really makes you warm and fuzzy about the car after this woman was carrying a gun because she was fearful for her life, which is why I call it WTF marketing. But that's going a little bit too far, I thought.
I got another question. In that, I do a lot of stuff in the make money online, which obviously they're looking at quite a bit of that. I'm curious about one of the statements. Is it necessary to say real specifically 95% of people that join this business will not make money, or do you have to just say, we can't guarantee that you're going to make any money with this business owner?
I can't answer this question definitively now, and there's not even a yes and a no with that one. FTC is real clear now. The latter, in part of your example, results not typical, that does not hack it anymore.
Right.
You have to actually explain what the typical user will expect. And so, you certainly don't want to say it, you wouldn't say it, 95% of our users make less than whatever, but it has to be said, even if you sugarcoat it a tiny bit, it's got to be said in a way that the average person can read that and understand what their most likely outcome is.
Yeah, so if you show like Bill Gates Jr. saying, he used our program and got, $1 bazillion, then you have to say, but, that only happened in so many cases.
The one example, and the FTC's example is in terms of a Weight Watcher type ad. The person says, I took this drug and worked out 6 hours a day and ate only steamed vegetables and lost 60 pounds in 2 months. And because those results are indeed typical for what you would expect for anybody who works out 6 hours a day and eats only steamed vegetables, no disclaimer was necessary. But if the woman said, if the ad simply said, I took this drug and lost 60 pounds in 2 months without disclosing the other lifestyle changes, that's when there would have to be, most of our users lose less than 5 pounds. However, with a strict diet and a active workout plan, you can get better results.
Does it have to be right on a page, or can you have a link to a financial disclosure?
No, it needs to be right there. That's one thing they're trying to discourage, is having the disclosures off somewhere. You need to be able to look at the ad as a whole and understand it without scrolling, linking, whatever.
What's going on is there's an evolution in the FTC, and they've been getting more research data on how the disclosure standards that may have been prevailing in the last 10, 20 years haven't been very effective. And so they're stepping up a bit on that. And so the things are changing. And we have a new FTC. There's 2 new commissioners coming in. One worked extensively with state attorney generals and consumer enforcement, particularly in privacy. So you're looking at a new regime for a couple of years.
Go to the far back and then back up to the gentleman who asked the first question.
Yeah, whenever
He's talking about Visa.
And so is it really anything seriously worth worrying about other than just being upfront and transparent about it?
Is it credit card related? And is there any personal or private information?
With trials with the negative option, so like they sign, like you put in your credit card and then at the end of 30 days they start charging you.
Yeah, a lot of some of the rules changed in conjunction with some of the credit card and financial changes and the red flags rules. There's a different topic for a different day, but if you do any kind of financing at all, and the way the government defines financing, theoretically, even a law firm who bills and does the work then bills for it later, that's financing theoretically, although they probably won't enforce it that way.
Oh, they get an exemption.
Huh?
They get an exemption.
They're gonna, okay, then
Yeah.
they should be, yeah, they're an exemption. But in any event, if there's any kind of financing done, they're now all sorts of, they're called red flag rules. So I'm getting the time card back there, so we're gonna have to close up the presentation part, but.
Very briefly on that point, there was a press release by the FTC working jointly with Visa and MasterCard, and Visa and MasterCard are cutting off some of the more egregious negative option plans. So that may be what you heard about.
Yeah, but if you want to give me a call next week, I'll tell you exactly what it said in your particular context. And for anybody that has any questions, my flight doesn't leave till tomorrow, so I'll stay here all day and answer any questions or talk about anything, internet-wise or not, that you want to talk about. Thank y'all so very much.
Thank you.